Right, this is in the matter of the people of the state of Michigan versus Michael Charles Spence, file number 23-21377FH. I have Rhonda Underwood appearing on behalf of Mr. Spence, and I have Christy Berta appearing on behalf of the Attorney General's office. This is the date and time set for sentencing. Mr. Moore is also, where is Mr. Moore? Mr. Moore is on Zoom. So, Ms. Underwood, have you had ample time to speak with Mr. Spence?
I have, Your Honor.
All right, and Mr. Spence, have you had an opportunity to read and review the pre-sentence report with Ms. Underwood?
Yes, ma'am.
Are you satisfied with Ms. Underwood and the advice that she has given you?
Yes, ma'am.
Okay. Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Your Honor, can we confirm that the plea was with a habitual?
Well, let me look at my green sheet. All right, so Mr. Spence pled on June 21 of 2023 to child support failure to pay with one habitual.
Thank you. I just want to make sure that that was correct. We have no corrections to make, Your Honor.
All right. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
It does not, Your Honor.
All right. And Ms. Berta, do you have anything to add to those questions?
I have no challenges, Your Honor. I would update the court as to the arrearage amount. It is now $18,251.38, accruing at $210 per month. Despite Mr. Spence's absence from the court for a significant period of time, no payments have been made since May of 22.
Okay, thank you. All right, the probation department has calculated the minimum sentencing guidelines on this offense to be 0 to 11 months. Do you agree with that computation of guidelines, Ms. Underwood?
We would agree with that, Your Honor.
All right, Ms. Berta?
I agree too, Your Honor.
All right, Ms. Berta, before the court passes sentence, is there anything you want to add on behalf of the Attorney General's office?
Nothing further, Your Honor.
Ms. Underwood?
Just a couple things, Your Honor. I believe Mr. Spence has had a lot of difficulties, both with substance abuse and homelessness, Your Honor, that have complicated his life quite a bit. I know he now is seeing his child, so we would ask that the no contact provision in the recommendation be modified to allow for visitation with the child. Mr. Spence, Your Honor, desires to get out. The first thing he told me is he's eager to get a job and begin making a dent in this, Your Honor. He knows he has to do that. And we hope he can start that today. Thank you very much.
Ms. Berta, does the AG have any position on the no contact?
I think while he remains under the court's jurisdiction that it is appropriate. And of course, if the family court were to determine that it was unnecessary, obviously, then I would ask that this court modify it. But at this point, I don't see a reason to modify the court's provision regarding no contact.
Well, I mean, okay, so I appreciate that. I don't have the ability just to sua sponte issue an order in a family court case. Mr. Moore, have you verified? Okay, Mr. Moore, if you verify that there is valid and appropriate contact with his minor child, I would have no objection to lifting that.
Okay, so right now there is a court order for no contact. That's why that's not, added into those probation conditions.
Right, and that's because of the nature of the filing.
Yeah.
But
yeah, if it gets dismissed, we can do an amendment removing it.
All right, so okay, so Ms. Underwood, I will leave that on, and then Mr. Moore can verify that in the next week or so. And if there is a desire for contact, we will obviously lift that. All right, Ms. Underwood?
Thank you, Your Honor.
Okay, so Mr. Spence, is there anything you'd like to say on your own behalf?
No, ma'am, that's it. I just wanted to see my son still. So, I mean, I I have been homeless, and yes, I know I need to get a job. Definitely start getting this taken care of, as well as get an own place to live, a secure spot.
All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing, the criteria and reasons for the sentence, and the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and protection of society. Sentence of the court will be placed on probation for a period of 3 years. During that term of probation, you will obey and comply with all the articles of your probation. I'll give you credit for 99 days already served in the Lenawee County Jail, so you will be released today. There is a $750 court cost, $450 attorney fee, $130 crime victim rights fee, $68 in state costs, $60 DNA fee. There's a monthly supervision fee in the amount of $30 or $60 if placed on tether. Mr. Spence, some of this can be taken care of with community service work. So not the arrearage in your child support, but some of your fines and costs you can work off in community service work over that 3-year period. You do have a history of alcohol abuse, so I am going to order that you're not to use or possess any alcoholic beverages or use any illegal controlled substances. And during the term of probation, you will obey and comply with all the provisions in your articles of probation. So we're going to send over to the jail 3 copies of your notice of right to appellate review. You're going to initial and date 1 copy for our records. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Mr. Moore, instructions for Mr. Spence.
Yes, he needs to report to me next Tuesday, either first thing in the morning or I would say between 8 and 11 a.m.
So Mr. Spence, obviously you're going to be out for a couple days before you report to Mr. Moore. Mr. Moore has a large list of employers and some resources as well. There are some homeless shelters here in town. So I wish you the best of luck, and Mr. Moore will see you next Tuesday morning, all right?
Yes, ma'am.
All right, now remember, you got to make your monthly child support amount plus pay on the arrearage, okay?
Yes, ma'am.
Okay, thank you. Have a good day.
Thank you.
Thank you, Your
All right,
Honor.
Thank you, Your
Mr.
Honor.
Thank you, Ms. Berta. Thank you, Ms. Underwood. Mr. Malaro. Let me see, Ms. Dunn's here. What is Ms. Dunn here on?
She's also on the Crusoe matter, Your Honor.
The what?
The Crusoe matter is Mr. Draper.
Oh, okay. All right, hold on. Okay, Mr. Draper and Ms. Dunn. All right. So Mr. Draper was here first, and you, Mr. Draper, you have Miss Ashley Cousineau. So does she. Let me find the file. All right, and she's in my waiting room. Okay. All right, Miss Cousineau, could you start your video and unmute yourself? Thank you. So this is in the matter of the people of the state of Michigan versus Ashley Marie Josephine Cousineau, file number 22-21022FH. I have David Draper and Celeste Dunn appearing on behalf of Miss Cousineau, and
Yes.
I am Alexander Bayonetto appearing on behalf of the people. I have a loaded prosecutor table today. So this is a date and time set for sentencing. This is a misdemeanor. And Mr. Draper and Ms. Dunn, you did receive a copy of the pre-sentence report from the district court. Is that correct?
Yes, Your Honor.
Yes,
All right. Okay, do either of you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Judge David Draper on behalf of Ashley Cousineau, we did have a chance to review the PSI with our client. We find it to be factually accurate. We would ask the court to adopt it And correct me if I'm wrong, counsel.
Hold
but
on, I'm just going through my questions. So my question was, do you wish to explain or challenge the accuracy or relevancy of any information in the report?
Sorry, Judge, no.
Okay, thank you. I just I don't want to lose my place in my spiel. So
That's
I
awesome.
show she has no prior convictions of any kind. Is that correct?
Yes, Your Honor.
Would you agree with that, Mr. Banetto?
Yes.
Okay.
There was some traffic down in Toledo, but that's.
Yes. Now, is there someone here who wishes to speak?
Yes, Your Honor, the victim and the kid.
All right, so Ms. Dunn and Mr. Draper, there is someone here that wishes to speak. So we will call them in a minute. And then I'll allow them to speak and then I'll let you guys speak, okay?
Thank you, Judge.
All right, thank you. So you can call.
What's wrong?
So I need you just to come on up to the podium and make sure you speak loud enough so we can record it, okay?
All right, thank you.
Can you tell me your name?
Deborah Rowe.
All right, thank you.
This entire ordeal is handled completely different than how I would have handled the situation. On 6/3/2016, I would not have blamed the 12-year-old boy who was attacked by the pit bull. He was simply trying to help get the pit bull and other dogs back into their yard. On 1/27/2017, I would not have blamed the 8-year-old little girl when she was attacked by the pit bull for simply walking across the room. On April 26, 2022, I certainly would not have blamed the neighbor who lived across the street from 124 South Monroe Street for 25 plus years for coming to the aid of a neighbor who is in desperate need of help. My neighbors are like family. I watched all the neighborhood kids grow up. They were all my friends, and we would help any one of them in a heartbeat, the same way that Scott and Gina helped me that night. I do understand being in a situation where you have an animal that is dangerous. I had a Dalmatian years ago that was the sweetest dog you could imagine. However, with age, she changed and began attacking another dog we had. We tried to keep the dogs separated, but one day our neighbor boy came over and opened our patio door, and the two dogs got together and knocked him down onto the ground and were fighting on top of him. He did not suffer even a small scratch, but I made the decision at that time that things were far too dangerous and I could not allow my dog to hurt anyone. We took her in the next day and had her euthanized before anyone got hurt. It was a gut-wrenching decision taking her in, but in our hearts and minds, we had no other choice. I could not have lived with myself if someone had gotten hurt, and I certainly would not have blamed someone else for my carelessness. Thank you.
Thank you so much. All right, can I have a seat? Thank you. All right, so Mr. Banetto, anything you want to say on behalf of the people? Stand at the podium, please.
No, Your Honor, not other than what's already been placed on the record at the time of the plea.
Okay, all right, so Ms. Dunn or Mr. Draper, who would like to go first or speak?
I'll be really brief, Your Honor. We would ask the court to adopt the probation's recommendation. I'll remind the court, if it probably knows, but Ms. Rowe is engaged, the Mike Morris Law Firm. There's a very significant, I believe, 2 insurance policies available. She's in excellent hands with counsel that's well known to defense counsel here as being very proficient plaintiff's attorneys. And I know that doesn't change things, but it is relevant, I think, to this ruling, I believe, even though no restitution is sought here, as it will be a separate matter in a civil matter. So we thank the court for its time. I know this has been a long, protracted case, but I think it's good that it's coming to an end at this time, and we thank the court for its patience. Thank you.
And even I see Mr. Morse's sign when I'm driving down to Easter Market. So,
Right.
All right, Ms. Dunn, is there anything you'd like to say on your client's behalf?
Oh, sorry, Judge. No, Your Honor.
All right, so Ms. Cousineau, is there anything you'd like to say on your own behalf? Ms. Cousineau, can you hear me?
Yes, I said no, thank you. I'm sorry.
Oh, okay. All right. Thank you. All right. So the probation officer who did the pre-sentence report stated this is a no contest plea. So there are no details about the case in the report. The defendant has had no further legal issues since this case started in 2022. And there is a civil matter So, and no restitution to be collected in this file. So the recommendation is for fines and costs. So, hold on one second. Oh, I must have had an amended information, so let me find it. So it's a sentence of court that you will pay $75 crime victim rights fee, $50 state costs. Is there a law enforcement fee on this one or no? I don't think so. Is there what? Law enforcement fee. Oh, that usually for that. And then a $250 fine. There will be no probation. I'll give you 60 days to pay that.
Thank
And
you,
you
Your
would
Honor.
pay that on the third floor at the circuit court clerk's office. It's a total of $375.
There's not a prosecution. Probationary. Okay. I'm sorry. Can you tell me again where
Ms. Kuzino, we'll reach out to you. We'll take
I'll
care of
say it
that.
again. It's fine. It's fine. So Ms. Kuzino, it's a total of $375. It's a $250 fine, $50 crime victim rights fee, and $75 crime victim rights fee and $50 in state costs. All right. And then you have 60 days to pay that on the third floor at the circuit court clerk's office, right across from the elevator. All right.
Thank you.
Thank you, Your Honor.
All right, thank you all. Now, Ms. Kuzino, wait, we're going to mail to you 3 copies of your notice of right to appellate review. And that envelope will also be a self-addressed stamped envelope. The first copy of that will have either like a little tag to sign here or highlighted. I need you to initial and date that copy, fold it up, put it back in the envelope and mail it back to us. That just acknowledges that you received your paperwork. The other 2 copies are for you, and if you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. I'm sure if you have any questions about that, Mr. Draper and Ms. Dunn would be glad to work with you on it. All right? All right.
Thank you, Your Honor.
Thank you. The record should reflect she did say yes, just we're not picking up audio. All right, thank you. Okay.
Am I good to leave then?
Yep, you can leave. Thank you.
Thank you very much.
Michael Dagger-Margosian. Hold on, I'll get to you next. All right, Miss Schumacher, Mr. Malaro.
Yes, Judge.
Salvatore Charles Malaro, that's new. Did you get a new computer?
No, the Zoom has a new format that's terrible.
All right. Too bad it doesn't have a camera. All right, so I've
I
got
tried,
Autumn in the
Judge,
waiting
I
room.
tried.
Yeah, that's what I keep hearing. So, all right, this is, let's get Autumn connected. Hold on, she's connecting to audio. No, she's still connecting. So, Miss Montalvo, are you connected? No, she's not connected. She's trying to connect. Okay. I'm gonna send her a chat. All right, Miss Montalvo, can you hear me?
Yes, I can hear you now.
Okay, good. So this is in the matter of the people of the state of Michigan versus Autumn Nicole Montalvo, file number 24-21716FH. I have Michael Dagger-Margosian appearing on behalf of Miss Montalvo. This is the date and time set for sentencing. Mr. Dagger-Margosian, you were present earlier when we were going through the PSI, so there might be some things because they're just duplicated to some extent. So I do show, let's see. Let's see. All right, so Ms. Montalvo, you had an opportunity to read and review the pre-sentence report.
I haven't. I don't know, actually.
Okay, so Mr. Dagger Margosian over here is your attorney, right?
Mhm. Yeah,
Have you met with him and talked about the pre-sentence report?
no.
Okay, Mr. Dagger Margosian, you need a breakout room.
That's fine. We talked a little bit this morning, but if there are questions, I'm happy to answer from Ms. Pablo.
So
I don't have any questions.
Well, no, now that I'm gonna put you in a breakout room with Mr. Dagger Margosian and you guys can talk about that pre-sentence report. All right, so go ahead and join. Mr. Malaro, I got Ms. Schumacher. So let me get her. So many files, okay. Mr. Malaro, oh, I forgot, you don't have a camera. All right, so this is in the matter of the people of the state of Michigan versus Tiffany Renee Schumacher, file number 23-21338FH. I have Salvatore Malaro appearing on behalf of Ms. Schumacher. I have Phoebe McClure appearing on behalf of the people. This is the date and time set for sentencing in this matter. Ms. Schumacher, you've had an opportunity to discuss the pre-sentence report with Mr. Malaro. Is that correct?
Yes, Your Honor.
Right, I'm gonna need you to speak up because the audio in that room is not the best. So if you can scoot up a little bit and speak a little bit louder, that would be great. So,
Judge, if I may,
yeah,
we're gonna ask to adjourn this out for a period of time, and the reason is there's an issue of restitution that I've been trying to resolve with Ms. Arnold. And along with that is, in our discussion, Ms. Arnold brought up the implication of filing a charge of continuing criminal enterprise, which is concerning to me given the nature of this case and how this was resolved. And it also, Ms. Arnold, I thought she'd be here today, is not.
so Ms. McClure is here with full notes from Ms. Arnold if you wanted to speak with her.
Well, with the issue of this filing a continuing criminal enterprise, that's a 20-year felony. And this restitution issue is not ever mentioned in our plea negotiations. And again, Ms. Arnold in her sentencing memo said that if the court were inclined to go below the Cobb's agreement, they want.
I don't have a sentencing memo. So I'm going to pause you right there, Mr. Malaro. That's fine. I don't have a sentencing memorandum, so I don't have that information. I'm Ms. McClure, briefly, do you have any objection if I adjourn this?
No, I just want to place on the record that sentencing memorandum was filed on April 17th. And this was set for sentencing on May 3rd, and it was adjourned at that time for Mr. Miller to respond to the sentencing memorandum and obviously to continue discussions on the restitution info. Following that date, May 3rd, there was a breakdown of the restitution information that's being requested that was emailed to Ms. Teskey, to your staff, as well as to Mr. Malaro. And it is Ms. Arnold's position that we continue with sentencing and that the PSI has now accurately reflected both the plea agreement as well as the guidelines, and that a restitution hearing be set.
Is there going to be a new charge?
The reason Ms. Arnold indicated that is if the court was not going to order restitution in this case, because it is obviously our position that restitution is permissible in the way that we're asking for it. But if the court finds otherwise, then we would have to in order to get the restitution ordered.
All right, so Mr. Malaro, are you asking for an opportunity to file a written response to the sentencing memorandum? Or
Well,
have you already and I just don't have it?
No, I've not filed it because I agree with Ms. Arnold's memorandum, but Ms. McClure just put on the record what the problem is. If this court does not order the restitution the state wants, they're going to pursue a continuing criminal enterprise charge. And I can't leave my client hanging like that. I just can't do that.
Okay, so I will tell you, we've not had a sentencing memo filed with the court. It's not scanned in. and it's not been received, so we never received a copy of that. So I guess at this point, if I adjourn it, does the sentencing memorandum address restitution in this file?
No, the sentencing memorandum had more to do with the recommendation as well as the PSI and the.
All right, so what I'm going to do is request that Miss Arnold and Mr. Malaro brief the issue of whether restitution can be ordered in this file. And then I'm going to set this out to June. Ms. Adams, what are we using, like June 28th or 27 or 2021?
Oops, June 28th, Judge.
All right, and I'm gonna set sentencing over to June 28th. I expect them to be filed and completed by June 24th. Because I don't want them the day before. So briefs both filed and exchanged by July or June 24th. No, June. Let's see, if we do the 28th, June 19th. Let's do June 19th. All right. And, all right, Mr. Malaro?
Yes, that's fine, Judge, thank you.
Okay. And Ms. Schumacher, we will see you back on June 28th at 8:15. Thank you.
Your Honor.
Thank you, Judge.
Thank you. Let's see, Mr. Daggermark goes in. All right, we are back on the record in the matter of the people of the state of Michigan versus Autumn Nicole Montalvo, file number 24-21716FH. I have Michael Daggermark again appearing on behalf of Ms. Montalvo. So, Ms. Montalvo, have you had an ample opportunity to discuss the pre-sentence report with your attorney?
Yes, ma'am, I have.
Okay, are you satisfied with Mr. Daggermark as your attorney and the advice that he has given you?
Absolutely.
Mr. Daggermark, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor, thank you.
Okay, so just to double check, in this, there was an agreement that any jail time should be suspended. And was part of the agreement any position on HIDA or?
She's not eligible, Your Honor.
Okay, okay. Well, I was just trying to make sure. And the information, there was nothing reversed out. So does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
None to my knowledge at this time, Your Honor.
You're not here on Montalvo, right?
Correct. I do
Okay.
have a victim.
You do have a victim here? Were they here on the other Montalvo too?
Not in here while you were already sentencing, so she.
Oh, okay.
Who's talking, Judge? I don't know.
I don't know. Could you state your full name for the record?
Christina Kidney.
She's from the crime victim rights. Yes?
Yes.
Okay, she's new-ish. Okay. All right, so let's see, we said no, the probation department has computed the minimum sentencing guidelines to be 0 to 17 months. Do you agree with that computation guidelines, Mr. Daggermark?
Your Honor, I don't have any challenges at this time.
Okay, so Ms. McClure, I believe there is someone here who wishes to speak. So come on up here. So you're gonna walk straight ahead and there's this little gate here you'll pull towards you. And then you're gonna go stand behind that podium, okay? Yeah, go stand behind the podium and very loudly, can you state your full name for me?
Erin Elizabeth.
All right, you're gonna have to speak up even more, so say it louder.
Erin Elizabeth Pickle.
Pickle? Okay.
I need spelling, Judge, please.
Pickle
Pickle.
and Ann.
It's Erin, ERIN.
Okay, now what would you like to tell me?
So me and my family have been harassed by her and her sister for 2 years now. This started in June of 2022. They showed up at my house, busted one of my front windows. Taylor was put on probation for this offense and everything kind of like died down for about a year. And then in September of 2023,
I woke up to what sounded like rocks hitting my window. So when I looked out there, it turned out to be Autumn and Taylor egging my house. And when I had moved my kids to a separate room, I came back into the living room and it sounded like they were trying to kick my door down. So I believe this was like the first attempt in their home invasion. I had called the cops, they ran. Cops didn't really do anything about that situation. So about a month later in October, I was taking my youngest to urgent care. And Autumn and Taylor had pulled up behind me, pretty much blocked me in. And this was like the first physical altercation that happened. Charges were pressed and from there PPO was put in place. And then less than a week later, these girls showed up at my house at 11 o'clock and pretty much tried to bust my door down. They cracked my whole door frame, put holes in my wall from my doorknob slamming and hitting my door frame. And on top of all of this, my children are all under 5. I have 3 children. They have been a witness to every single altercation that has happened with these girls. My children are affected from this. My children can't even sit in the living room when somebody is knocking on the front door anymore. So I would ask you, not for me, but for my children, to please punish these girls. I already know Taylor has been sentenced, but I believe this, they should be in jail for this. My kids are traumatized and this has not stopped and I don't believe that it is going to stop. So that's it.
Do you know why they do this?
Autumn is upset because her children's dad and I were involved 2 years ago. So it's all over the place. And my kids fell victim to it every single time.
Thank you.
Thank you.
All right, Mr. Dagamarkosian, is there anything you'd like to say on behalf of your client?
Your Honor, I think it's probably appropriate to set the record straight on what's going on, or at least add additional factors here. What wasn't put on the record during the victim impact statement was culpability on Ms. Pickle's part, culpability on her significant other during this incident, throwing Autumn and Taylor physically down the stairs. So I'm just going to leave it at that. What I will say is that I believe that the recommendation does take into account the conflict happening between these parties. Obviously, no contacts will be in place. That is appropriate. The suspended jail makes sure that Autumn stays in line. I'd ask the court to file the recommendation.
Ms. Montalvo, anything you want to say on your own behalf?
I just want to say that Erin is constantly, even yesterday, she's constantly making TikToks talking about me, talking about my children, being molested, all sorts of stuff. Like my kids' dad has nothing to do with the issues between me and Erin. She caused the issues herself, but I'm done with the issues. Like I've learned my lesson. There's a no contact put into place. I'm not bugging the girl anymore. She's the one that's still constantly putting stuff on social media, just constantly involving drama. I'm out of the drama. I don't want nothing to do with it. I've left the girl alone, haven't done anything. I'm not going to do anything. And that's it.
Determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication of the law, and the protection of society. So this is like 6th grade girl drama.
Yeah.
And we are way too old for this. And women should, first of all, never behave this way. Second of all, never involve children. There is no reason children should be afraid to sit in their front room, be in a car with a car pulling up. I had a friend who was harassed by a man in a truck driving down 223 the other day. And now she's, frightened. I mean, we just don't have the right to do that. So Ms. Montalvo, I hope that you are done with the drama, as you say. But I think also, hopefully, everybody gains a little maturity and this stops. I can't stop people from social media posts, but as an adult, you can stop letting them get to you if it is true. Do you understand?
Yes.
All right, so Ms. Montalvo, if it continues though, you're gonna be looking at jail. Do you understand?
I understand, yes.
All right, so it's sent to the court, you'll be placed on probation per the agreement for 18 months. It will suspend the 6-month jail term, but understand if there is one violation, then you're looking at 6 months in jail. Do you understand that?
Yep, I understand.
You will obey and comply with all the terms of probation that are given to you by Ms. Walsh. There is a $130 crime victim rights fee, $30 supervision fee, $60 if we have to put tether on you, $750 in court costs, $450 in court appointed attorney fees. There is a $60 DNA fee if we need that. I don't know if you have a prior felony. $68 in state costs. I'm going to order that you take a parenting class as well as an anger management class. Ms. Walsh is your probation officer. She will set up a monthly amount that you have to pay. So you have to gain employment if you don't already have it. And then I'm going to put a curfew in place of 11 p.m. to 6 a.m. barring employment or medical emergencies. Do you understand that?
Yes, ma'am.
Now, Ms. Walsh, are you going to have a report next Tuesday?
Tuesday at 1 p.m.
So next Tuesday at 1 p.m. you need to report to Ms. Walsh. If you're employed and that's an issue, call Ms. Walsh and she'll work with you on that. Do you understand?
Yep, I understand.
All right, now you do have the right to appeal this sentence, and we're going to mail to you an envelope that has 3 copies of your notice of right to appellate review and a self-addressed stamped envelope. You're going to, the first copy will be highlighted or flagged in some way, initial and date that one, fold it up, put it in a self-addressed envelope, put it in your mailbox or a drop box and mail it back to us. That way we know you received the paperwork. The other copies are for you, and if you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, and the no contact will obviously remain in place. Anything else, Ms. Walsh?
Ms. Montalvo, is your phone number and address still the same as it was when you came and saw me?
No, my phone number is the same.
Wait.
No. Hold on. I'm going to put you in a breakout room.
Do you have my number?
Yeah, I was going to call you. I was going to say it with her. And
go ahead and just text me your phone number and your address, okay? And then actually just call me.
Okay.
Okay.
All right, Mr. Degemer goes in. Anything else?
No, Your Honor, thank you.
All right, thank you. All right. So. Mr. Blumerick is here. Mr. Degemer goes in. Are you ready on Mr. Blumerick?
I think we are. I think this was just put on the docket to allow the victim to make a statement. So we're ready to proceed.
All right. So, Mr. Blumerick, why don't you come up here? Mr. Murphy, can you have a seat at this table for me? Just because that you'll see. Have a seat. All right, Mr. Blumerick, come on up to the podium real quick. So this is in the matter of the people of the state of Michigan versus Nicholas Taylor Blumerick, file number 2024-21713FH. I believe, if I remember correctly, when we sentenced last time, was it, they were not here at the time we did the sentencing, is that correct?
Yeah, I think it was moved up at the request of probation for, I think maybe treatment program, yeah. And we didn't get the notice out to victims in time.
Okay. All right, so Mr. Degemer goes in for purposes of today. What's the matter?
I just wanted to adjust the mic, please.
He can do it. No, he can do it. There we go. Next time. All right, so Mr. Degemer goes in for purposes of today. Do you want me to start from the beginning, or do we, for the purposes of the victim as well? Okay, we'll just do that. Mr. Hernandez, have a seat. All right, so what Mr. Degemer goes in?
I was just gonna say, we don't need to, I don't think we need to start from the beginning. I think it's just to give the victim an opportunity to speak if Ms. McClure agrees with that.
I think technically because it's a resentencing, I think we do have to do it, just so we're following all the rules.
All right, so Mr. Dagger Margosian is here on behalf of Mr. Blumerick, and I have B.B. McClure appearing on behalf of the people. This is the date and time set for a resentencing, and Mr. Blumerick, you've had an opportunity, obviously, the last time to read and review the pre-sentence report with your attorney.
Yes, ma'am.
And you are satisfied with Mr. Dagger Margosian as your attorney and the advice that he's given you?
Yes, ma'am.
All right, Mr. Dagger Margosian, I don't believe you did last time, but you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor, thank you.
Ms. McClure?
No, Your Honor.
All right, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? Mr. Dagger Margosian?
No, Your Honor.
All right, on count one, larceny from a motor vehicle, the probation department calculated the minimum sentencing guidelines to be 2 to 17 months. And on count two and count three, financial transaction device stealing, retaining without consent, and then illegal sale or use, to be 0 to 17 months. Do you agree with that calculation of guidelines?
No challenges at this time, Your Honor.
Ms. McClure?
I agree.
All right, just for the record, Mr. Blumerick has been involved in participating in the recovery court program. And as of this time, he is very successful at this point. So, Mr. Blumerick, I'm gonna have you have a seat right there next to Mr. Murphy. And then, I believe that we have someone who wishes to speak, so you can bring her up over here to your right, Ms. McClure, over there, yeah. All right, and ma'am, you're just gonna come up to this podium, okay? All right, and then I need you to speak really loud. Can you state your full name for the record?
Barbara Littrell.
Okay, you take that mic, kind of bend it down to you. Can you spell your last name?
Luttrell.
Thank you very much. So speak to me, okay, but what would you like the court to know?
On December 16th, I had just got out of work and stopped to get gas in my vehicle and got in my car, took my debit card out and went to go pay for my gas. I had pulled a 10-hour shift. I just went in and to get me coffee and get my gas in my vehicle so I could go home. I came back, started pumping my gas, went to put my card back because I took it out of my wallet, left in my truck. I did not lock my truck, just walked away. There was only one other car there. So whenever I walked back to put my debit card away, my purse was missing, my wallet was missing. I went to the front, I had left my cell phone charging in my console in my truck, and that was gone. And I had walked back in, I noticed the car was sitting over there. I thought it was someone that worked at the gas station. So I went in and talked to the lady that was working there, and she called the police for me. He got there quick, he must have been close by. But in the meanwhile, I had walked over and checked my truck again and then walked over to the dumpster thinking maybe they threw it in there. It wasn't nowhere. So whenever the cop came back, he got there, I explained everything that had happened. And I took in, the lady came out and said that up at Myers, the store, the people that view the cameras were already in there. So he knew him by name. He went in there and I had to go just a 10-hour shift drive all the way back to come see to my daughter's house to start this process of trying to shut everything down with no phone. This person took my wallet. He took all my personal information. I had pictures of my grandchildren that no one needs to be seeing on my phone. And it was a nightmare. Until right now, it's still a nightmare because I'm still fighting to get everything back. It was December 16th. I had to cancel all kinds of orders that I had bought my grandchildren Christmas gifts. It's just been a nightmare, and I feel very violated over this situation. just because I walked away and did not lock my vehicle does not give anybody the right to walk and get in someone else's vehicle. He had all my information. I was worried about someone showing up at my house, you know, so all I got to say is just, I feel that something, you know, punishment should be, you know, get a job. I work hard for what I have. I'm a single person trying to take care of myself, and it's rough, but get a job. Stop going out stealing from people. It's not right.
Thank you. All right, Mr. Bloomer, you want to go back up to the podium? So, Mr. Dagenmark or Ms. McClure, anything you want to say on behalf of people?
Just that I hope, obviously, Mr. Bloomberg is successful in drug court, and I hope he turns his life
We
around.
call it
and
recovery court.
I'm sorry, in recovery court. And I hope no one else has to go through what Ms. Michelle went through.
Okay. All right, Mr. Dagenmark goes in. Anything you'd like to say on behalf of Mr. Bloomer?
Not too much, Your Honor. I think it's very easy to sympathize with Ms. Luttrell. I'm sorry that everybody's sorry that she went through it. Mr. Bloomer knows that his conduct is inexcusable, and the purpose of recovery court is to set people straight so that this doesn't happen again. So I'd ask the court to just impose that.
All right. So, Mr. Bloomer, obviously we sentenced you previously, and then you've since been involved in our recovery court program. And why don't you talk a little, is there anything you'd like to say on your own behalf?
Other than I apologize. I do apologize. That was she, and I do see where she's coming from, and it wasn't me. I'm changing. I'm doing good in recovery court. I do just apologize.
All right, so ma'am, I will say that as we all know in this country and others, that addiction has many victims, including the people that use the drugs, but especially the people they victimize. And in this case, you were victimized based on his addiction, and his theft was for purposes of feeding that addiction. And you know, he's doing good right now. He's sober. It doesn't make it easier for you to do that. I also, one time I used my card at, I think it was a Wesco back when they had that big thing, and the number got picked up, and I was going on maternity leave, and somebody took like all this money out of my account, and it was just traumatic. And it took me 6 months, at least 6 months, to get everything sorted, because it's just a lot of work to do that. So I apologize for that, and I hope that all gets settled. You know, we are working hard with Mr. Bloomerick and the other people in our recovery court to help them overcome their addiction and make changes in their life. And you're employed now, right?
No.
Oh, he's a stay-at-home.
Stay with my baby.
Yep, so he's a stay-at-home dad at this point, because his partner is the financial earner in the family. So, but he will be gaining employment, and I do want you to know, ma'am, and I don't know if it makes it any better, but he is very successful so far in our recovery court, and I do have high hopes for him. So in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law and protection of society. I would also add that when we put people in jail, we don't give them treatment and then they get out and they reoffend and they reoffend and they reoffend. Recovery court is not an easy program. It's rigorous, it's demanding, it's traumatizing at times. It's a heavy, intensive program. So he's not getting off easy, but he did choose to do this program. And that shows to me maybe this will never happen again. Like, he will not cause someone else the pain that he caused you.
Thank you for bringing that up, because I did choose it because I've been through so many different options and ways, and I want to try something different.
All right, so it's a sentence of the court that you will be placed on probation for a period of 3 years. You're ordered to enter and complete the Lenawee County Recovery Court. Will give you credit for 6 days already served in the Lenawee County Jail. There is restitution in the amount of $150 payable to Barbara Luttrell. There's a crime victim assessment fee in the amount of $130, $30 supervision fee, $60 if we have to put you on a tether, $750 in court costs, $450 in attorney fees. There's $204 in state costs, which is $68 on each count. There's 3 counts. And as I said, you must enter and complete the Lenawee County Recovery Court Program. I will further add that as a former defense attorney, I represented Mr. Bloomer a long time ago, I think, and he's in a better place now than he's ever been in his life. And your addiction started when you were 13. So he's 32 now, and hopefully these changes will be permanent. So, all right, now you do have the right to appeal this sentence, and my bailiff's going to hand down to you notice of right to appellate review. Please initial and date 1 copy for our records. The other copies are for you, and if you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days.
All right. Thank you.
Thank you.
Thank you.
Thank you. And Ms. Luttrell, I want to thank you as well for so eloquently talking about the impact it has on people when this happens. So thank you. I should reflect, I see back a copy of the notice of right to appellate review. Thank you. All right, so I believe maybe Mr. Dagamagosi, you're all set, right?
I think I'm all set, Your Honor. Thank you.
All right, so now I have Mr. Hernandez. So this is in the matter of the people of the state of Michigan versus Pedro Hernandez. I have multiple files today. So I have file number 23-21526FH, and that's the one that's set for sentencing today. Correct, Mr. Murphy?
Yes, Your Honor.
And then I have file number 23-21325FH. And that file is set for sentencing. Yes?
Yes, Your Honor, that's the violation of the tether being at one of the dispensaries, I believe.
Is that file being dismissed upon sentencing on this file?
Well, I'm not sure what, well, I think because that's a,
This violence.
why is it a different file?
That 325FH is an, I think it's an old probation file.
Does he have a probation violation on that or no?
It's a show cause on 325, Judge.
It's showing as an old domestic violence in my case, or in my system.
Is that the show cause Mr. Coast for violation of bond conditions or no?
Judge, of the violation of bond conditions 2023-50380. So it looks like I believe he's going to be sentenced on the first contempt, and I was looking to move to dismiss that second attempt. Or
So,
contempt.
Your Honor, from my understanding, I'm sorry.
No, I'm sorry. My understanding was that was on a PPO file, not on the 325 file.
Correct.
Okay,
I don't
Yes, Your
know.
Honor.
I don't know that anything's going.
hold on. Miss Adams, my boss is, I think she's talking.
Yep, that was a show cause from Mr. McCarron on February 16th.
Did we already deal with it or no?
No, it was adjourned to today.
And that has to do with the underlying cases that are pending at district court, so that we wouldn't want to do anything with until after the trial in August.
Okay,
Yeah.
so that's just gonna get adjourned out again?
Yeah,
That
there's
is-
yeah, August 7th, I think, is when that.
Okay, so file number 23-21325FH, we're gonna adjourn out till,
The trial, I believe, is August 16th.
so Miss Adams, can we adjourn it out to like August 21?
That would work, Judge. Oh, nope, I apologize. We can't do that day.
August 28th? No? September 4?
September 4 is good.
Okay. So could we get a notice for him today on that one?
Yes, Judge.
So the pre-trial and the show cause on that file, 23-21325 FH will be adjourned to September 4th, 8:30.
Yes, Your Honor.
Okay, so I thought we still had the show cause on.
There's sentencing on the OWI charge. There's a sentencing on the show cause, the violation for being at the dispensary. I believe Mr. Coast may have had a new pending one that he was saying he wants to dismiss. If I'm not mistaken.
Yes, that's correct.
Okay, so now we're left with just file number 23-21526 FH. And that is the one that is set for sentencing today. I do show, okay, so got this. Hold on. Pre-agreement. All right, so and you guys have a show, Mr. Coast, there's a show cause on this file as well for the tether, correct?
Correct, Judge.
No.
That's the most recent one I'd like to have dismissed. The first one, I believe he has the sentencing. That's on the PPO file.
Yes, and I think we're.
Can we
gonna-
have the PPO file number because it's not on my docket today?
It's 50380.
24
It's a 23
50.
380.
So that had a show cause from your office, Mr. Coast, and you're asking to dismiss it?
Yes, ma'am.
Yes, and I think we're gonna try and simplify this because once he's sentenced here, he has nothing else pending here other than that show cause. Everything else is being handled in district court, and that show cause that he is here is actually being supervised by district court. So our position at this point is to get rid of that GPS tether order through this court. I believe end supervision through Mr. Coast.
Right.
And just let district court handle the matters. And if they think a tether needs to be ordered, they can do that in district court. But I think at this point, we want to end that supervision.
Right, once he's sentenced, Mr. Coast would no longer have anything to do with it.
Apparently, he's doing something with the PPOs.
Oh, yeah.
So, but that's what I'm saying. Let's
So you're
that-
fine with Mr. Coast not monitoring him anymore on the PPO once he's sentenced?
Yeah, I think it would make things a lot easier.
Yeah, because it's.
Man, but this.
Just hold on, Pedro, stop talking.
Yes, John, that's what my understanding, because again, with the trial being downstairs on domestic violence, that's stemming the new violation. That just makes sense to us as well.
Okay. So Mr. Hernandez, remember what we talked about before? You have to just be quiet and to speak when you're asked to, okay? Because sometimes you tend to get going and say stuff maybe you shouldn't say, okay? All right, so Mr. Murphy, have you had an opportunity to read and review the report with your client?
Yes, I reviewed it with Mr. Hernandez. We've gone over.
Oh, hold on, Mr. Hernandez, you've been able to read it?
Yes, sir.
And you've discussed it with Mr. Murphy?
Yeah.
You're satisfied with Mr. Murphy as your attorney and the advice that he's given you?
Yes, he's done everything.
Okay, good. Is that a yes?
Yes, sir.
Okay, Mr. Murphy, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Your Honor, just one thing, everything seems accurate except for on page 6, the family narrative. It says the defendant was born on 3/25/200. I think that should probably be.
He looks good for his age.
Yeah, I think he's not biblical age, so I just think that may be an inaccuracy. Other than that, everything seems accurate though, Your Honor.
So Mr. Stevenson will have to fix his date of birth. Okay, any challenges for you, Ms. McClure?
No.
All right, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
Ms. McClure?
No, Your Honor.
Probation Department computed the minimum sentencing guidelines to be 7 to 23 months. Do you agree with that computation of guidelines?
Yes, Your Honor, I have no challenges to that.
All right, you as well, Ms. McClure?
Correct.
All right, before the court passes sentence, Ms. McClure, anything you want to say on behalf of people?
Nothing on behalf of the people.
Mr. Murphy, on behalf of your client?
Your Honor, we're just asking the court to adopt the recommendation of probation in this matter. I believe, Your Honor knows Mr. Hernandez, the situation he's in. Obviously, he has a very, I would call it advanced case of ADHD that he tries to struggle with. I mean, it's a struggle in speaking with him and in trying to deal with that. Luckily, he's employed. He's been employed for a long time, which is a very good thing. You know, in regards to the matter, the alcohol use was something he used to try to cope with stuff going on in his life, and he knows that was a big mistake, a big, you know, issue with that was, you know, again, that he had no other option, we didn't know what else to do. He's learning that now. He's a really young man, so again, at this point, Your Honor, seeing him at the beginning of his adult life, he knows he's made mistakes, he knows he's had poor choices, and I do believe that moving forward, he's gonna, you know, do what he can to try to correct that behavior. Obviously, he understands it's a process, and that's one of the things that he has to deal with is when he makes mistakes or there's issues, he tends to overreact, he tends to have that, you know, with that anxiety that he has, so that's something he's working on right now. But quite frankly, Your Honor, I believe he's doing everything he can to correct his life, and I would ask the court again, just to adopt probation recommendation. I think that's appropriate, Your Honor.
Okay, so Mr. Hernandez, we talked about this before. I mean, everybody has something, whether it's allergies, depression, anxiety, ADHD, whatever it is. I have ADHD. It's not that there's something wrong with you. It's just another thing, you know.
Your brain moves faster than everyone else.
Yeah, and so does your mouth, and I get that. So we had talked about perhaps you going and seeing a doctor about trying to find a combination of meds that would help you. Because obviously when you have drug and alcohol issues, you're probably self-medicating.
Yeah, I was definitely using alcohol as a coping skill. I just didn't have no one to teach me none. And since I've been out there at the lake, I earned a lot of resources and a lot of people that I can go to, and they've been guiding me. And, you know, so I just been using my resources and just trying to, you know, your brain's the most strongest muscle in your body. And if you execute your brain, you're good at life. And I just, you know, I was lost in the chaos in this town. I didn't really see what life could truly be like. And I thought there was only one way of life. And once I was able to see that there was another way to live, I'm not. Yeah.
Have you gone to see a doctor about maybe finding a medication that?
Since I've been on house arrest, I've really just focused on getting myself, I just got myself a home for me and my kids. So now that I got a home, I can start jumping the hurdles. You know, I'm trying to do step by step.
Okay.
But I am definitely gonna work towards getting that. That is because my ADHD causes my depression.
And causes your problems.
Yeah, so I think once I execute that, it'll execute a lot of other things.
Okay. Anything else you want to say?
Absolutely.
All right, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing, the criteria and reasons for the sentence on the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication of the law and the protection of society. So it's sentence to the court that you'll be placed on probation for a period of 2 years. During that term of probation, you will obey and comply with all the articles of probation. Do you understand that?
I'm not worried. I'll listen to whatever you've done.
Okay, well done. So you've already served your continuous 48 hours. So I'm not recommending any further jail as of today. Do you understand that? Say yes.
Yes, Your Honor.
Okay. During this term of probation, you cannot possess any alcohol. You can't even use mouthwash with alcohol. All right. I know.
Really?
Starting today, no,
Really?
no alcohol in it. All right.
I didn't even know that.
Or don't want anything to pop up, so you're using alcohol.
Yeah, and no cough syrup with any alcohol in it. Nothing.
Oh, wow. All right. Yeah.
So we use honey as a cough syrup, so whatever. So just be conscious of that, because if you come in and say, well, I gargled like 5 minutes before I took my test, you'd still be going to jail.
Yeah, I'm not.
I don't buy that. Okay.
Nothing's worth my future.
Okay. So you must comply with all testing, not to use any illegal controlled substances. You must pay the cost of substance abuse testing. You must complete outpatient treatment. So he's probably going to order you into an assessment and treatment. Make sure you get involved in that. There is
Could you I just got done going to Catholic Charities and I liked it there.
Yeah, you can go there, it's fine.
Okay.
Right, I'm gonna order 40 hours of community service work. So that means you gotta volunteer somewhere doing stuff. Mr. Stevenson has a list of all the places you can do community service work.
Would like help with the homeless or like just?
Yeah, you can feed homeless people, walk cats, I don't care, wherever, okay. You cannot drive a motor vehicle. You do not have a driver's license. So you have a bike, skateboard,
I'll
Whatever.
buy one of them scooters if I got.
Yeah, buy a scooter.
Serious.
Unless you need a license for it. If you
Yeah.
need a license, you can't drive the scooter. All right.
You do.
So, your license is revoked, and so that's gonna be a process. So you're gonna have to maintain a period of long sobriety, attend AA, do all these things to be able to get your license back at some point. You
That's my
understand
next
that?
goal, so
Huh?
that's my next goal, so.
Well, it's gonna be a long road.
That's fine.
Okay.
I'm willing to wait.
Okay, so there's a $30 per month supervision fee. Let's see. $750 in court costs, $450 court-appointed attorney fee. There is $68 in state costs, $130 crime victim rights fee, supervision fee. I think there's $60 DNA testing fee. I'm going to order that you get a mental health assessment and follow any treatment plan recommended, okay?
About that.
So there's a bunch of different medications for ADHD and they monitor them up and down.
Yeah, I used
Like,
to
yeah.
get that.
I think we
have
talked
to-
about Vyvanse. Some people have symptoms on, some people don't. So you find the med that works for you, all right?
Now that I'm older and I'm more alert, I'll be able to maybe find the right one.
Maybe, yep, and you just gotta be proactive. Mr. Stevenson, anything else?
I just need him to report Tuesday at 9 a.m., Tuesday, 9 a.m.
Okay, Mr. Coast, anything?
Judge, as far as the tether, are we removing that? Are we keeping that on him?
Yep, that'll get removed today.
Okay. Yep.
So you'll be off the tether.
I'm-
Behave,
I'm
Mr.
saying that
Hernandez.
today.
No, don't argue, just you behave.
Oh, I'm working. I'm not letting nobody mess up my future no more.
Cause I'll put that tether right back on you. You know you,
I'm not doing.
okay. Are you still working at this restaurant and,
I'm still there. Now that you're allowing me to get off tether, I can do more to help. You know, I'm not just stuck in one place. I can go to all three. You know, I can do everything now, so.
okay. All right, so, Mr. Coach, you want to meet with you in the hallway for instruction on that or? Okay.
Yes, I can
All
meet
right.
him in the hallway, Judge.
Okay, so you said 9 o'clock next week, Mr. Stevenson?
Yes, on Tuesday.
Next Tuesday. Look at me. Next Tuesday morning at 9 o'clock, you gotta come here and meet with Mr. Stevenson. Mr. Stevenson is a great probation officer. He will give you all the help you need, but he also will not put up with any nonsense.
You don't play bullshit, I know.
Yeah, no, we don't play. So,
I'm,
it's okay. It's okay. So my bailiff's gonna hand down to you a notice of right to appellate review. I'm gonna have you, oh, Miss Adams, I need those, please.
Printing it right now, Judge.
All right, so in a minute, we're gonna give you your notice of right to appellate review. I'm gonna have you initial and date one copy. That's for our records, so that I know you received your paperwork, okay? The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Then you're gonna go sit in the hallway and Mr. Coast is gonna come explain to you how to get your tether off.
Okay.
All right?
All right, Your Honor.
And anything else? And when do you report to Mr. Stevenson?
Tuesday at 9 a.m.
Good. All right. Anything else?
Your Honor.
Mr. Clerk?
I would say two things. One, if district court requires as a condition of their bond,
I'm
the
fine.
tether,
I
they
mean-
aren't gonna take it off, but this order's ending. I don't know what your bond looks like down in district court.
So Mr. Coast, we might need to verify what his district court bond has.
I'll do that this morning.
All right, they're gonna check, because you might be required to wear a tether in district court, so they'll check on that, all right?
And if you are, we can talk about.
At least give me a curfew or something.
Mr. Murphy, thank you.
You're welcome, Your Honor. 5 cents? Yeah.